Do you need a lawyer to administer a trust? This usually comes up whenever we have a person who sets up a revocable trust for the purposes of avoiding probate. And when they pass away, they designate someone as a successor trustee. So the successor trustee then becomes the owner of or entitled to the property that's held in the trust, and they can take care of distributing the assets to the various beneficiaries. Whether or not the person needs or should have an attorney depends on the complexity of the trust. A trust, once the person who set it up passes away, is supposed to obtain a federal identification number, because it then becomes a separate tax-paying entity. And so that whenever any income comes in, it's not taxed to the successor trustee under their individual Social Security number. There can be also questions if this is an ongoing trust as far as what duties you owe to the various beneficiaries. Under the Florida statutes, a successor trustee is to send or notify the beneficiaries of the trust and that they are beneficiaries. There also should serve upon them an inventory letting them know what assets are in the trust. And further, if it's an ongoing trust or takes some time to administer, they should send out an annual accounting and giving the beneficiaries notice that if they have any complaints about how the trustee is handling the finances of the trust, they have 6 months in which to object. One of the most often asked questions of the successor trustee is what do I have to do as far as paying the creditors of the deceased settlor or the person who set up the trust? This is somewhat problematic in that there maybe not be a probate proceeding, and the trustee would be responsible for paying those bills. A notice of trust should be filed with the clerk of the court. The question is, well, should I make distribution of all these assets, and then what happens if a bill comes in? Well, that is a real problem as far as giving the successor trustee a definitive answer, and that the creditors can file claims or sue the estate and trust up to 2 years after the person's death. So it's important to understand who the creditors are and do a reasonable search to determine the ascertainable creditors. The other issue is filing a fiduciary tax return. That is a tax return by the trustee that reports whatever income has come in, and then sending out the notice to the beneficiaries of how much they must pay in taxes. So all of these are matters that need to be addressed whenever you become a successor trustee, and it's usually sometimes not within the successor trustee's expertise if they are not a professional trustee in order to do that. So it may be wise to consult with an attorney and discuss with them whatever trust that you may be the successor trustee to determine just exactly what you need to do and whether or not you need to engage the services of the attorney as far as the administration of the trust, so you do not become personally liable for any of the debts and be protected as far as the beneficiaries are concerned. If you'd like some advice or set up an appointment to discuss administration of a trust, well, give me a call at 727-847-2288.